everyone. It's our next session for our Access CPC session. Just it's about a minute or so before our scheduled start time, so we're going to kill a couple minutes here and wait for a few more people to join the call. Many of the same people on the line today as yesterday, which always makes it great for us because there's a couple little things that are kind of housekeeping in nature and also minorly repetitive. By the way, this down here says updated March 2022. It was not. It was updated in the spring, so ignore that screen. It wasn't updated on the update screen. And we're going to quickly review a couple of things about CPC in the beginning, and then we're going to jump into our session. But as I mentioned, it's great to have a lot of the same people in because anything that's repetitive, we're going to skip over real quick and try to set a goal for being out of here before 4 o'clock today. Before we proceed, for the people who were on the call yesterday, is there anyone who has any questions from yesterday that we can clear up before we jump into our session? Okay, great. I'm going to repeat a couple of the rules of our webinar process. I don't monitor the comment sessions while I'm trying to stay on topic. And Jen will be, our administrator will be popping in and out. So if you have a question, our group is a decent enough size that you can just unmute your microphone. And if you want, you can turn on your camera. That's up to you. And just interrupt me and say, hey, Steve, I got a question about that. It's very possible that I will say things in a confusing fashion or maybe get mixed up and use the wrong words. And it needs to be corrected. So feel free. As a matter of fact, I really appreciate it when you do that. It lets me know that you're awake and you're still there. I haven't bored you to death. So please jump in and ask the questions. If it is a question about something that's on an upcoming slide, I'll let you know that and we'll move on to that slide. And also, we're going to take a break at around 2:30 today. It'll be a 10-minute break at 2:30, so I'll try to time it properly so we can take a break. And when we do take a break, you can turn your mic, keep your microphone off and your camera off, but don't leave the webinar because that means I have to go and administer things to admit you back into the room again. And I probably won't do it right. So just put it on pause there, turn things off and go do your business and then come back after 10 minutes. All right, so first off, I want to congratulate everyone for making the decision to take their CPC through ACSESS. People that the CPC has been around for, I can't even remember, when we first created it 25 years ago maybe. And there are thousands of people who have received their designation across Canada. ACSESS is the only organization that is offering a certified personnel consultant designation in Canada or any professional designation in Canada. And ACSESS is the only organization representing the industry, both on the perm search and temporary staffing and contract side of the business. And doing that with governments and legislators and the general public and customers in every province. We've got chapters everywhere, and we encourage people to be involved and active in their chapters because very often that's kind of where you hear first about what things are happening in the association. But your CPC designation is proof to your customers and to your candidates and to your coworkers that you are taking your profession seriously, that you've made a commitment to maintaining a professional standard in the work that you do, and that you do things right and you do things correctly and you do things ethically, and you become a better resource for your company, for your coworkers, for your customers, and for your candidates, so that things are done in accordance with the law, in accordance with ethics, and using best business practices in the industry. So I congratulate you for being one of the special people who's made a decision to pursue this professional designation. Okay. Yesterday, as I mentioned to you, there are 5 modules that must be taken. And down here, I don't know if you can see my mouse when I move it around, but down here, the Brown 1 recruitment and selection, we've got a new module that was introduced last year. It's been offered 3 times so far. One was at conference in May in Montreal. maybe 2 times. And one was at conference in May in Montreal. You have a choice. These 4 business practice ethics, legal aspects, health and safety, and legal aspects are all mandatory. And recruitment and selection is one of the optional. Sales, professional staffing sales is the other option. You could take one or the other. Up to this point in time, everyone who's participated in it have taken both because they're both fantastic programs. And then, of course, at the end of having 5 or 6 of your courses, you take the CPC exam, and the CPC exam is multiple guess. And I'm going to repeat things that I've said many, many times before, that it's not important that you memorize all the fine details. It's more important that you understand what the principles and concepts are, what the topics are, where to find answers to those topics, that the issues exist, so that when something comes up in your company, in your operation of your business, and with your customers and your candidates, you can say, hey, wait a minute, I think we need to do this right, and I know where to go find the answer to it. And you can look up things like the number of weeks of notification that are required to a person, and you can calculate a person's pay properly and things like that. You can look up, and you'll know what to go look up, I guess is the right answer. I don't try to memorize all these things. Some of the things don't change over time, and many things do. And sometimes I'm surprised that they did change, and they just kind of slip in there. So it's always important, even if you think you know it all, to go and double check, because the legislation is constantly changing. And as we mentioned yesterday, most of everything that we do in our industry is provincially legislated, which means that every province and territory has the opportunity to create their own version of employment equity and their own version of privacy laws and their own version of employment standards. And so what we might teach here in generality that seems somewhat consistent across all the provinces and territories, each area, each province is going to have their own subtle and unique differences. And so please always take the time to go look things up. So today we're going to talk about human rights legislation and how it exists provincially and federally, what it's trying to cover, and how we can approach it. We want to identify some of the issues around human rights practices, around applications, hiring, and various forms of discrimination, and how we can accommodate people with invisible minorities and disabilities. This is going to be our first session. I think it was kind of there in the spring while we were talking about it, but since Donald Trump has been elected, diversity, equity, DEI, and inclusion have become in the United States a dirty word. I mean, it's just incredible how such a honorable, decent principle has been, I'm going to say, manipulated to take on a meaning of which it was never intended in another country. And of course, we're pretty close to the United States. And so all of that news and some of that popular thinking crosses the border and can affect us. So we're going to talk about it in reality and what diversity, equity, inclusion means in Canada. And not necessarily what you hear on CNN or Fox News. We're going to talk about privacy legislation and how it's created, what's intended to protect, and what we have rights about. And also we're going to talk about how this affects us as employers and suppliers, and how it can help us or hurt us in our business if we don't really understand it. So we've got, from a big picture standpoint, today we're going to look at human rights. We're going to look at employment equity, which is a federal legislation that affects provincial suppliers to federal industries. And remember, yesterday we talked about in employment standards, we're provincially legislated. And so even if our customer is federal, we abide by and are fall under the authority of the provincial legislation in the province that we work out of. And yet, employment equity is an interesting one. If you're a contractor to the federal government, they want you to participate with them in achieving their goals. If you supply a certain amount of business, and a certain number of people, they want you to participate with them. And so there's an employment equity program we're going to talk about, and where we're talk about diversity and equity and privacy. So first off, from a human rights perspective, human rights describes how we instinctively expect to be treated and what each of us are entitled to. And the human rights legislation describes how we should treat others, or to some degree, not treat others. And so it deals with the concepts or the principles of treating people with dignity, treating people with respect, respecting where they're from, their heritage, their culture, their looks, their shape, their gender. And it is not, and it's about equality of opportunity. It's about treating people in the same way as we go through the hiring process. So human rights, like the other legislations that we talked about yesterday, are federal and provincial. So if you are a provincially legislated industry, as we are, then our human rights rules that we abide by are written by our province. And if the federal government and banks and railways and airlines and those industries that are federally regulated industries would fall under the federal legislation. And so the interesting thing is that the federal legislation was created first, and it all is consistent with the goals and objectives and principles of the Charter of Rights and Freedoms, which really is about human rights, mostly about human rights and equity, and as a result, and privacy. And as a result of that, the provinces were given the opportunity to basically copy the federal legislation and just use it verbatim, the way that it's written federally, or to tweak it and modify it on its own. So they're fundamentally and substantially similar. The wording is a little different. Some of the emphasis and the order that they put things in are a little different. The process for complaints and handling issues are a little bit different, but at the end of the day, they're the same. Because if, say, for example, someone were to make a charter challenge and say that, hey, that way that I was treated is a violation of the Charter of Rights and Freedoms, and it's not covered properly under the Human Rights Act. And so the Human Rights Act might then adopt some common law principles. In other words, a decision might be made in the court saying, yeah, they should have included that, or I think that's what that means. And this is how the courts now say. And so then the federal government now kind of has to include that in their interpretation of the Canadian Human Rights Act. And that law now becomes the law of the land. And so each of the provinces is going to have to find a way to do something substantially similar in their provincial legislation. And we're going to show you some examples of how that, in fact, did happen, that the Charter of Rights and Freedoms was written and the Human Rights Act was modeled to be consistent with the objectives of the Charter. And then some people appealed and challenged some of the issues, and they won in court. And so then the government came in and literally changed the statute. I gave you an example yesterday of that, how that happened in employment standards, but in human rights, how they go ahead and change the standards to be consistent with the decisions that have been made in the courts. And so we've got the Canadian Human Rights Act, which is federal statute. We've got the Charter of Rights and Freedoms, which is part of the Constitution. And we've got the provincial legislation that regulates us, for example, the Ontario Human Rights Code or the Alberta Human Rights Code, and so on. The human rights legislation applies to all of the following practices of employment. And by the way, human rights legislation doesn't only apply to employment, it applies to things like the opportunity to for housing, equity in housing, to provide services to people in business. There's how people are treated under the law with respect to benefits and insurance. There's a lot of it that is related to employment. And so things like recruitment advertising, how referrals of employees and customers are handled, how referrals of employees from customers or other employees are handled, how we handle promotions and demotions and training, how we set wages for our workers, the questions that we can ask and the information we collect in our application forms, the questions we ask and the information that we document, and the decisions that we make in our interviews, how we establish apprenticeships and who is qualified for apprenticeships, things like employment transfers from business to business, location to location, and any other matter really relating to employment or the application for prospective employment. So very often when we talk about human rights, we get these broad stroke principles that are written about that are very uplifting and honorable and decent about what we're trying to achieve. And then what happens is so often is that the legislation spends its time talking about, therefore, these behaviors, these things are wrong and would be in violation. And so, just like roads, we talk about the principles of road safety, but at the end of the day, we write laws about what you're not allowed to do, what speeding limits are, and what the penalties for breaking the speeds are, and how you have to drive, and how you have to signal, and all the things you could do wrong, and if you do them wrong, what the penalties are. So, a good portion of human rights focuses around the issue of discrimination. Discrimination is an action or decision that treats a person or a group of people or a group negatively for things such as race, age, disability, and other grounds. These are known as grounds of discrimination, and there are 11 grounds that are protected under the Canadian Human Rights Act. And then, of course, each of the provinces models those 11 grounds in their provincial legislation. And, to me, a lot of them, like race and national or ethnic origin, to a degree, color, not necessarily. These all kind of start to fall into where were you born, what is your heritage, what is your cultural background, and they use different words to describe it because sometimes one word or one topic doesn't cover them all, but they're often very similar. It also includes religion and age. Now, of course, there are some issues, so I think we'll talk about this in a little more detail later on about age. You kind of can discriminate against people under a certain age. In other words, you can treat them differently, probably for their own protection or because they don't necessarily have the rights. They don't have the rights to vote and the rights to, have a bank account or something like that under a certain age. And they've been removing age discrimination on the top end. So, for example, we no longer have mandatory retirement ages in Canada because they were removing the top ages. So there's a little bit of ageism there. Sex or gender discrimination, sexual orientation, marital status, family status, disabilities, and one that people always want to talk about because it's a little confusing is a conviction for which pardon has been granted or a record suspended. I think, I'll talk about that now, and if it comes up in another slide in a little while, I'll just skim over it. But this one is pretty straightforward. A person gets convicted of a crime, and you can use that information in your determination. You are allowed to use that information in the determination as to whether or not a person is qualified for the job, so long as the nature of the conviction or the crime is in some way relative or related to the work that's going to be performed and the responsibilities of the job. So you want to get a job in a bank and you're going to have access to people's credit cards into their bank accounts, and you've been convicted of fraud, then it would be a bona fide occupational requirement to say the person must be free and clear of criminal convictions for which they have not been pardoned for. In other words, we won't hire convicted criminals, fraud criminals to work at the bank. And that makes perfect sense. And so you are allowed to use that information, except for eventually a person who serves their sentence and they're granted parole, and then they pass a certain period of time, they can make application for a pardon, which basically means I've been good for so long and I've paid my penalty. You can no longer use that information against me. That would be discriminatory because it's no longer relevant to the circumstances of today. And so a record can be suspended or expunged and pardoned. And so we ask the question, have you ever been convicted of a criminal offense for which you have not been pardoned for? And then again, of course, if, for example, if a person is shoveling snow or laying sod, whether or not they've not paid their bills and had a criminal offense for something or speeding, I don't know if that's going to be relevant to the employment. And so we can only really ask questions for which they're related. And so here's one of the examples I want to give you where decisions were made in the courts, and then it became common law, and then the governments went back and made it statute. So the original Charter of Rights and Freedoms and the original Human Rights Act of Canada and provincial legislations did not include any references to sexual orientation. And so LGBTI persons were not specifically mentioned or covered. And so in this case, going way back to 1995, 30 years ago, Egan versus Canada, the Supreme Court of Canada held that although sexual orientation is not listed as a grounds for discrimination, so it's not one of the 11 prohibited grounds, or 10 at the time, prohibited grounds in section 15.1 of the Charter, it constitutes an equivalent ground on which claims of discrimination may be based. So in other words, they're saying this is kind of the same as some of these other things that we've prohibited, except for they didn't think about it and put it in the Charter and put it into the legislation. So then, a couple years later, Friend versus Alberta in 1998 went to court, and the court held that in provincial human rights in Alberta, that the legislation had left out grounds of discrimination. In other words, they said it should have been included, but they left it out, and it should have been there in section 15.1. And so now it became common law because two courts had said the legislation is wrong. And so then 2 years later in Parliament, in the federal government, Bill C-23 was passed. So they made a change to the Human Rights Code, which gives same-sex couples the same social and tax benefits as heterosexual heterosexual couples in common law relationships. And so we talked yesterday about common law marriages. So you get married, there's a statutes around that, and there's licenses for it. Then you act like you're married, so you will live together for in some places it's 2 years, some places it's 5, or maybe it's always 2 now. But you act like you're married, and eventually you're in common law marriage, which means that according to the courts and to society, you're just the same as the person who's got the certificate, so you should get all the rights and benefits. And then they came along in the legislation and said, so homosexual couples or same-sex couples are the same as common law relationships. And so they then granted them the same rights. And these rights went towards things like social benefits, like Canada death benefits on Canada pension plan, and then access, and then tax benefits. So you could use your partner as for an RSP spousal contribution, and the married deduction from your income, which then started to extend into private world. So things like insurance, so that same-sex couples could get family group insurance policies through their work. And it expanded from there in common law, which meant the courts recognized it. And so then the government said, well, geez, we've now got this in common law in Alberta. We've now got this in common law in federal Supreme Court. We've now passed legislation that says common law couples, um, homosexual couples, same-sex couples would be the same as heterosexual couples in common law. Then they went one step further in 2005 and said, let's modify the Civil Marriage Act and allow same-sex couples to get married and have that piece of paper. So it's not just common law. And so this became a perfect example of how the charter sets out principles, the government writes a statute that tries to say what the principles are, writes all the rules and regs and the penalties and how it's going to be enforced and so on. And then the courts evaluate it and decisions are made and they become common law. And then we go back to the statutes again, and eventually the courts make changes to the statutes so they become consistent with the common law. So that was a really perfect example of that. Adverse effect discrimination is a policy or a practice that can unintentionally single out a person or a particular group of people, and it results in unequal treatment. This type of unintentional discrimination is called adverse effect discrimination. Adverse discrimination is not good, but it's not necessarily intended. So some examples of adverse discrimination. Requiring employees to wear a promotional uniform that conflicts with a person's religious clothing requirements. So when they set out to make the policy, they weren't intending to discriminate against a group of people or people differently. As a matter of fact, they wanted everybody to be the same. But then they found out through some court decisions that infringed upon a person's right to wear their religious clothing and maybe had to modify things. And I'll give you an example in a few minutes of a case where that happened, or some cases where that happened. Establishing a work schedule that uniformly rotates employees in a rigorous and rigid order. So in other words, you work a week of day shifts, then you work a week of afternoon shifts, then you work a week of night shifts, then you work a week of, and you rotate through these shifts. And so everybody in the factory or everybody in the whatever, in the gold mine, are all given the same opportunity to work on days and work on nights and work in afternoons. And so it's not discriminatory, it's fair. Except for there are some people that might, for example, have children and can't work at night. And there's other people that might have a particular religion and they can't work on Friday evenings or Sundays. And so this uniform rotation, which was intended to create fairness and be a good policy, ended up being discriminatory. Standardizing office furniture. So you decide you're going to have a staffing company, and this is what the model looks like, and you've got interview rooms, and you've got a reception area, and you've got consultant areas, and you've got open bullpen where recruiters are all working together to fill job orders, and so you buy the exact same sizes of desks, and you have the architects build the models exactly the same, and then you start to find out that different people have different abilities and disabilities and sizes and shapes and so on, and allergies or something. And you find out that this standardization of office furniture would seem to make your business run more efficiently, may be infringing on a person's individual rights. And so accommodations must be made. So the interesting thing about adverse effect discrimination is that it's discrimination, and it's bad discrimination, but it's not the bad discrimination. It's the kind that people had the proper intentions in mind. Maybe they ought to have known and thought it out a little bit better, but generally the solution to that problem is change the policy or accommodate people because the policy isn't perfect and doesn't fit everybody all of the time. And then there's the other kind of discrimination, which is systemic discrimination. And so when you hear about things in the news and they talk about systemic discrimination in the RCMP or in the post office or in XYZ company, and in the fire department, the discrimination against women, these are systemic discriminations when the discrimination happens because of a business practice or a workplace policy or a program that discrimination is not limited to a single incident, that they didn't, so in the adverse effect, they didn't anticipate how they might affect this one person who's got these special circumstances. In systemic discrimination, it consistently and persistent and consistently, I said consistently twice, so that's very consistent. It consistently discriminates against a group of people, um, and it might even be perceived like, hey, you should know that this is discriminating against a group of people. And so it can um, affect a large group of people. And so that's a bad policy. It's not one that you say, oh, geez, I didn't anticipate how this could affect this one person with this one special need. This is like consistently, affecting women, or consistently affecting Aboriginal people, or consistently affecting people with disabilities. And so those policies need to be changed, not just accommodated. They need to be changed. And so these are the kind that often find their way to the Human Rights Commission. So if it is a normal way for things to be done in the workplace because it's a policy, practice, and procedure, and it has a negative impact on those who are racialized, then it's considered to be systemic. So examples of systemic discrimination are criminal background checks. I mentioned earlier, a criminal background check for a person who lays sod would systemically and persistently discriminate against people who have got a criminal record. Regardless of their criminal record, they might be eliminated from the opportunity to lay sod, which had no basis in their qualifications, ability, reliability, and performance with respect to putting that grass on the ground. Recruitment practice such as favoring or limiting to word of mouth. So when you're using referrals only, and you don't advertise and you don't make things public and so on, then you tend to get more of the same. So if you've got all young people working in the business, they probably are more inclined to refer their friends who are also young people. And so by only relying upon referrals, then we are systemically discriminating against people who are older. Same can happen with religions and families and cultural backgrounds. Steering of applicants to certain jobs or assignments based upon their race or gender. So what would be a good example? So assuming, for example, that all the women, this would be a stupid assumption anyways, but I'm going to use it for example because it's obviously stupid, that all the women should be referred to nursing, college, and nursing jobs, and all the men should be referred to medical school and doctor jobs. Well, that's ridiculous. And yet, at some point in time, I'm pretty sure that society kind of viewed things that way. And so that would be systemic discrimination with respect to gender. Historically segregated occupations or industries. So, you say, hey, these firefighters have always been men, and they should be men, and we only let men fight forest fires. And that would be maybe something that existed 25, 35, 55 years ago. But sticking to those historical segregations for occupations and industries are no longer permitted. Job ads showing preference for young, energetic, recent grads, men only, women only. We talked yesterday about the recent changes to the Ontario Employment Standards Act, where putting things in advertisements that said only Canadian experience, relevant Canadian experience. We have to remove the word Canadian because the question is whether it's relevant experience, not Canadian experience. And so job ads that show preferences to people that would be discriminating based upon one of the 11 grounds of discrimination. A customer preference. This is a tough one. If the customer says, I don't want any people of this race to service my account, or I don't want any people who are too short to service my account, then I don't think shortness, if it's within the range of normal heights, is a prohibited ground. So if a customer said people with this race or this religion are the only ones that are allowed to service our account, then that would be a problem. And by the way, I just to give you an example, there's an issue. I mentioned yesterday that we own a home care company. And so we get all kinds of seniors particularly seniors who are developing dementia, and seniors who have been in Canada who um, uh, their original language is not English. And as they start to develop dementia, it's common with that disease that people tend to forget English and they revert back to their natural language, their original language. And so families say, well, we'll only take caregivers or nurses or people to assist mom or dad if they speak Italian or Greek or Portuguese or Chinese or whatever their language is. And um, and so on the face of it, that would be systemic discrimination, that we're allowing customers to arbitrarily decide, except for um, I guess that you could say it's a bona fide occupational requirement that if you've got a person with dementia who needs to be cared for, and part of it is maintaining their social well-being and their mental health, and you have to communicate with them in order to find out if they need to go to the bathroom or they are hungry or if they're in any pain, and you can't speak their language, then much the same as a person who goes, say, for example, who goes to court is entitled to have an interpreter. In other words, it's required that the courts accommodate a person in the language of their choice, then the same thing could go to home care, where a person who they need the care in that language because that is the fundamental thing that's driving the need. So if you said, hey, I need a car, and you said, oh, that's discriminatory. You have to take a truck because we've got trucks too, but they don't want a truck because they don't need a truck. They need a car. Then telling people that they have to take something that doesn't fit their need doesn't work properly. So there's this thing called an occupational bona fide requirement. And so we'll talk a little bit about occupational bona fide requirements in a few seconds, which could be, in the case of our home care company, language. But generally speaking, in the absence of these kinds of very specific and special circumstances that I just described to you, generally speaking, that would be customer preference systemic discrimination. There's issues with big data. Boy, this is a real big issue these days with AI and algorithms and social media algorithms and the sorting of data and using AI to determine a person's qualifications and making big general assumptions about how people might ask the questions or where they got educated or something. So big data has the potential to be very problematic. It doesn't and hasn't yet tended to be a huge issue in the media and in the courts, big data systemic discrimination, because it's so complicated, people can't figure out that they're being discriminated against. They just suspect that they are. If you think about the movies about the communities that are being polluted and people are getting sick, and how much work goes into years and years and years of doing research. People suspect that it's the pollution from the industry down the road that's making them sick, but too complicated for the average person to actually figure out and make a complaint about legitimately. And so it takes years and years and years and lawyers and movies and public policy to kind of get there, to get it fixed. We're kind of at that stage with big data, with algorithms and with AI. We all suspect that there's something going on, and can we prove it and can we stop it? And so the first step, for example, yesterday, I told you about the recent changes in Ontario with respect to AI, where now, if there's any part of the process where AI is being used, it's not prohibited. You can use it. You just have to tell people it's being used. So the first step is for them to say, okay, I'm aware of the fact that there's something that might go wrong, that could go wrong, that could be used inappropriately, or could sway the information in a particular way. At least I'm aware of the fact that it's there, so I can conduct myself appropriately through the process also, and not have it work against me unintentionally and unwittingly. So big data, systemic discrimination, and AI, systemic discrimination. Personality or customer service tests. So things like traits and colors and all of these personality tests are usually very validated, to determine, is this person assertive, or are they passive, or are they organized or disorganized? But using them inappropriately could result in systemic discrimination. And then, of course, physical ability tests and capacity tests and cognitive tests. I mean, if they're not really validated, they're not not in the language that the person understands, and they're not relevant to the job, they could all be systemic discrimination. Mandatory religious practices by employers who do not qualify as a religious organization. So, so for, what would be an example? Well, say, for example, this is not a good example. Catholic school boards. Catholic school boards used to require that all teachers were Catholic, and they from their priest saying, yeah, Mary does come to church on a regular basis, and she's got an envelope, and she pays us money, so she must be Catholic. And so this practice has, over the last 20 years, has been significantly diminished because Catholic school boards have not been deemed to be a religious organization like church. They're an educational organization, and people who are not Catholic are allowed, students who are not Catholic are allowed to go to Catholic schools. And so setting out these mandatory religious practices of proving that you're Catholic in order to work as a janitor in a Catholic school just doesn't make any sense anymore. English only rules, I think that's pretty obvious for a lot of jobs that don't require a lot of great English. So some more are age-based limits, not right. Mandatory retirement dates, systemic discrimination. Waivers that may prevent employees from filing complaints, can't do it. Can't say, hey, you're not allowed to complain if we do something wrong. Discrimination. No fault attendance policies. I talked yesterday about cause for termination. You can't have I don't care why you were late, 3 strikes and you're out. We've got all kinds of accommodations written into the statutes with respect to people's children and their family status and their family illnesses and their own personal health and all kinds of things. So there's no place for systemic discrimination. For example, if you've got a single mom with 5 kids, might end up missing some more days of work than other people, because every time that they're 5 times more likely than a person with no children to have a sick day, because one of those 5 people might be sick, and they got to try to accommodate that sick child first thing in the morning. So no fault attendance policies is the problem. Can be systemic. Light duty policies for only work-related injuries. So if you show up for work, you say, oh, I hurt my back on the weekend, and then you say, oh, you're fired, that would be discrimination. Requiring a person to be 100% capable of doing their job before they're able to return to work would be systemic. Pre-employment medical inquiries, boy, this is controversial. I mean, alcohol clears out of your system in a very short period of time. I don't know how many hours, say 24 hours or something. So if you drink today and test tomorrow, you're going to test 0. But THC remains in your system for a long period of time. So we're hiring a person to be a driver, and we force them to have a pre-employment medical test that shows that they had THC in their system, but they hadn't consumed any for 3 days. And they consumed it on their own personal time on the weekend, and it's legal. And then not hiring the person because of the presence of THC in their blood or urine test, or however they test for that, would be considered discriminatory. So these pre-employment medical exams and inquiries really need to be validated to ensure that there's a relevancy to the job and the medical questions that they're looking at. So when we compare these 2 types of discrimination, adverse discrimination, the accidental and easier to fix discrimination, against systemic discrimination, which is just a really bad policy and hurting a lot of people and potentially, if it continues, is going to result in some penalties and issues. So adverse discrimination is intended to be a good policy that unwittingly or unintentionally has an impact on a person or a certain group of people. However, it's a good policy, that we all wear a uniform and that we promote the company with our logos on it. And that may require occasional effort to accommodate a person. So, hey, it's okay that you don't wear our shirts. Our shirts don't fit your body. We don't have any of your size. So just, wear something same color. Or it's okay that you wear your religious headdress and don't wear our hat. The hat doesn't serve any safety purpose, and it was just for promotional purposes. So go right ahead and wear your religious headdress. So it's easier to accommodate people through adverse discrimination, but systemic discrimination requires an overhaul. This systemic discrimination is not a good policy because it regularly influences or causes discriminatory results. So we got to change that policy. So when we've got these discriminatory policies against the 11 grounds for discrimination, we then got to ask ourselves, well, can we reasonably, and particularly if it's adverse effect discrimination, can we reasonably accommodate the person by adjusting something to the system to accommodate or make fair the same system for an individual based on a proven need? So accommodation can be religious, it could be academic, it could be employment related, and often mandated by law. It's often mandated by law that because common law, there's been court cases saying, yeah, you got to let this person not work on Fridays, or you have to help this person to wear different clothing or something like that. So things like reasonable accommodations might be, we're going to run more Aboriginal, First Nations and Inuit advertising in the local community centers and newspapers. And we're not just going to run them on Indeed or use referrals. The job advertisements in a Chinese language newspaper. So if the community has got 20% Chinese people because you live in Chinatown and you have no Chinese people working in your company because it's all done through referrals, then I would say, hey, this is pretty easy for you to accommodate. Let's just start running these advertisements in a different place. An apprenticeship program that is directed toward people with disabilities or older work that isn't. So we can just say, hey, we need to modify our apprenticeship program so that we give equal access to and invite people with disabilities inside our company to come and participate in our apprenticeship program. And that maybe our apprenticeships are not only for recent graduates, but they made a movie out of that. I think it was called The Apprentice. For older workers to come and make a contribution under apprenticeship programs. Installing software or features on software, keyboards. And Microsoft offers a whole variety of system settings to assist people with physical, visual, and auditory disabilities. And so installing software and features, and nowadays so much. I mean, I remember 30 years ago how hard it was using Dragon Dictate and some other really, old school methods of using voice to text, whereas now everything's voice to text. I'm in the car talking to people, sending text messages. Hey, Siri, send a text message too. Changing the schedule to accommodate religious practices, and I'll give you an example of that in a few minutes. So a requirement, the Latin word bona fide or bona fide means kind of real and credible. Not exactly the exact interpretation of the words, but it means a real and credible need for a requirement to be changed. So in a bona fide occupational qualification, BFOQ, is what they call it in the United States, and a bona fide occupational requirement is often what we call it here in Canada. They're exactly the same things. As a quality or an attribute that employers are allowed to consider when making decisions on the hiring and retention of employees. And so we might say, for example, Um, the law allows us to, um, uh, the law allows us to, um, will not allow us to require a person to carry more than 40 pounds. I don't know what I should talk in kilograms. I don't know what the law is, but the law might say, hey, it's against workplace health and safety legislation to require a person to have to regularly lift more than 40 pounds. Except for, um, this is out in the field and it's in the back of a truck and there are no lifts and there are no cranes and there are no fork trucks. And every once in a while, one of the things that goes out to the job is 60 pounds and it's got to come out of the truck. And if it doesn't come out of the truck, we can't build the widget or can't do the thing. And so a person has to be able to, from time to time, lift 60 pounds. Otherwise, the job just can't get done. And so if you can prove that this will cause irreparable harm or unreasonable damage to your business, then we can say, yeah, it's a bona fide occupational requirement that the person can occasionally lift 60 pounds. And so they'd say, well, that normally would be discrimination against, say, for example, women who typically don't have the same body size and shape to lift as much as men. Not saying that some women can't lift as much, but on average, I mean, this isn't a thing, right? With fire departments, it's an issue. Do women have the same qualification standards as men? And so you can say, yeah. So another one might be example, you've got this heritage building. It's a old fort with 3-foot wide stone walls, and there's a jail in the basement, and the person gives tours of the jail. But the jail was designed in such a way that there were these narrow pathways that were only, 18 inches wide, and they were designed that way so that if someone broke out of the cell, they would have to slither between the wall here, and then slither back way that way, then slither this way. So they have to go through the little maze of slithering. And of course, the guards could just take a gun at the other end of the slither path and say, hey, get back in your cell, buddy. And the person could not get away. So I just made that up. I don't know if that exists. But I can imagine them doing that, saying, oh, people go escape from our jail all the time. Let's create this hard way for them to get out, this other hard way for them to get out. And then the person giving tours is large and doesn't fit in the slither path. And so they can't give tours to skinny people, skinny enough to get through the slither path. And so the large tour operator can't give the tours. And so you say, hey, if you want to have this job, you have to be able to slither down the skinny path. And then they could say, well, okay, if the job is only to slither down the skinny path, then larger people can have the job. But if it's just a part of the job, if it's only 10% or 2% or a small part of the tour, is there any way that we could reasonably accommodate that? Could we say could that person stand outside the slither path and give people directions to walk in and come back out again? Could you have a different person do that part of the tour? Is there a way to reasonably accommodate that person? And so is it a bona fide, a real incredible requirement that will require, okay, so that was a ridiculous example, but I made it up to make the point that it needs to be really obvious. And sometimes you think it's obvious, but it's confusing because you could accommodate the person. But let's say, for example, you are hiring a priest to work at the church. Well, I think it's pretty reasonable to say that it's a bona fide occupational requirement that you are an ordained priest and that you have to be Catholic and you have to be an ordained priest. And so being Catholic is a bona fide, a real incredible occupational requirement. In order to be a Catholic priest, you wouldn't want to hire some people of a different religion to be a Catholic priest. And so we can justify that because it's real and incredible. And yet some people might say, hey, we need to have a servant of the community that can administer public weddings. So they could be of any religion. So if your only job is to be a servant of the community to justice of the peace or an officiant, you could be of any religion. And so in the case of hiring Catholic priest, we can say religion is a bona fide occupational requirement. And in the case of the officiant, we say no, the being certified to issue a certification of marriage is the requirement, not the religion. And so we couldn't say you have to be a Catholic priest to be an officiant in the community. So the difference between a bona fide occupation, real incredible. It can be a real incredible thing that on the face of it looks like it's discriminatory, but there's a real incredible reason that justifies it. And there's this real incredible reason that it justifies it, but can we accommodate it? Can we get around it? So these are the two: reasonable accommodation, bona fide occupational requirement. So in the case of the dairy case, number one, Mr. Christie was employed by the dairy pool and became a member of the Worldwide Church of God in 1983. So we're going back all the way to 1983 because this is one of the first cases, and we very often look at the case precedent that is going to tell us how this law came to be. There's been thousands of cases since then, but this is one of the first in Canada. So became a member of the Church of God. Church recognizes Saturdays as the Sabbath and 10 other holy holidays throughout the year. Members of the church are expected not to work on these 10 other holy days and on Saturdays, the Sabbath. And Mr. Christie was asked by his employer, went to his employer and asked for permission to take off Tuesday, March the 29th and Monday, April the 4th. So, because both these days were holy days in his church. He was granted leave for the Tuesday. You can take off Tuesday, March 29th, but you can't take off Monday, April the 4th. Because in 1983, at the dairy, Mondays were especially busy days because all the milk that was collected over the weekend had to be processed promptly on Monday mornings and Mondays. It was all hands on deck. And this was to prevent the milk from spoiling so that it didn't sit there Saturday, Sunday before it was pasteurized or processed or whatever they needed to do to milk. Now, of course, dairies are far different now, and farms pasteurize or do things to the milk before it's even shipped to the dairies to be bottled and cartoned and bagged. So there's a whole bunch of different processes. But remember, this is 1983. So when the day came along, Monday, April the 4th, Mr. Christie didn't show up for work. And so his supervisor didn't like that and terminated his employment. The Board of Inquiry ruled that Christie was discriminated against because his religious faith had not been accommodated, that they felt that there could have been this reasonable accommodation. They could have found somebody, a temp or something, or maybe he could have come in on Sunday and done something, I don't know, and done it on Sunday when it wasn't a Sabbath for him. However, this decision was then overturned by the Alberta Court of Queen's Bench and the Alberta Court of Appeal, because I guess the dairy was able to establish that this was really important. Milk goes bad. Now, listen, I don't know the more details about this case, but let's assume, for example, there's only 2 people, and you need 2 people. They didn't have 3 or 5 or 10, there wasn't 100 people there, that there's 2 people. And you need 2, you can't go with 1. The work can't be done with 1, and he didn't show up for work, and all the milk went bad. And if a guy doesn't show up for work unexpectedly in the future and all the milk goes bad, then that's cause for termination. So the Board of Inquiry originally found that the employer had made no significant effort to accommodate the request, and that they were able to establish this bona fide occupational requirement. So the bona fide occupational requirement in the appeal was particularly important to this thing. So they said they could not accommodate this guy reasonably in any reasonable fashion. Of course, there's you could say, oh yeah, it costs us $1 million to get another company to come in and do this, and therefore we wouldn't lose $2,000 worth of milk. That would be unreasonable. So what a reasonable accommodation is. You have to establish, one, was there a bona fide occupational requirement? Was it so important that we were allowed to do that? Number 2, Was there a way to accommodate the person under reasonable means? What is reasonable? What's the definition of reasonable? Can we establish reasonable, what reasonable means? And so all of these things have to be argued in the court. So in the case number 2, CNR, the Canadian National Railway versus the Canadian Human Rights Commission, in 1985, again, we're going back to the beginning of some of these rules, the Supreme Court of Canada decided the requirement of wearing a hard hat is a bona fide occupational requirement and amounted to discrimination on the basis of religion, which entitled a Sikh worker to continue his employment without having to wear his hard hat. So in other words, they said, hey, it's not a bona fide occupational requirement. You can accommodate this person, reasonably accommodate this person. He can wear his religious headdress. He does not have to wear a hard hat. And so when they looked at it, they said, hey, here's the thing. There's no shortage of, this guy was a maintenance electrician. They had lots of maintenance. They had, unlike the dairy where there's 2, they had lots of maintenance electricians. And Mr. Binder wasn't unique. There was lots of other people with the same qualifications as him. And the employer safety policy wasn't going to be jeopardized by giving Mr. Binder an exemption, especially if he was willing to go and we'll do the work over there instead of the more dangerous head-banging work over there. So if you work over here, you got a chance of hitting yourself in the head. If you work over there, it's outdoors. There's no things swinging around by your head. You can work outside or you can work in the office. You don't need to wear a hard hat. So could he relocate to a post where a safety helmet wasn't necessary? Although he wasn't willing to, and it was okay. It was reasonable for him to not accept another job, say, for example, as a clerk or as a janitor. He still had to be given, he still only wanted a maintenance electrician responsibility, but there were lots of different posts and things to do as the maintenance electricity at this railway. He was able to perform effectively and efficiently without a safety hat. It wasn't affecting his productivity, and he wasn't putting in danger other workers or the general public, and so no one else was at fear of being hurt if he didn't wear a hard hat. And the risk of injury to him was not that great if he doesn't wear a hard hat, particularly if he relocated to another spot. So they said, here's all the things that we took into consideration to determine whether we could reasonably accommodate him. And because he could be easily or reasonably accommodated, it was not a bona fide, absolute incredible requirement that people must be able to wear a hard hat and not wear a religious headdress. So discriminatory practices. If you're all in the room, we get everyone to raise their hands and say hi. Which of the following is not a discriminatory practice? So denying someone goods, services, facilities, or accommodation based on a prohibited ground. Well, of course, that's discriminatory. Denying an employment opportunity based on a bona fide occupational requirement. It's a bona fide occupational requirement. You must be Catholic in order to be a priest. It's bona fide. It's real incredible. So we can deny the non-Catholic person that job. That's not discrimination. Paying men and women differently when they're doing work of the same kind. Well, that would be discriminatory. Retaliating against a person who has filed a complaint with the commission or against someone who has filed a complaint for them. So this is called a reprisal. When a person reprises or penalizes a person in almost like a vengeance and vendetta kind of form, firing them for their job, not giving them a promotion, ignoring them, treating them badly. So retaliating against a person who has filed a complaint, you are allowed to file a complaint. You're allowed to make an inquiry. Even if you fail in your complaint or your requirement, you're allowed to make it without being penalized for questioning. Harassing someone, well, yeah, you can punish a person for harassing someone. That's not a discriminatory policy. So this has to do with the janitor. In a unanimous decision, the Supreme Court of Canada restores a decision of the BC Council of Human Rights, which found that Mr. Smith was in fact discriminated against by both his employer and his union because of his religious beliefs. So this custodian, Seventh-day Adventist, his belief prevented him from working from sundown on Friday night to sundown on Saturday, and the work schedule required him to work on Friday night shifts from 3 p.m. to 11 p.m. And I said, it's really common was, I don't know if it is anymore, it was really common in schools and school boards for the school gymnasium and maybe their theater to be, and sometimes even classrooms, to be rented out to groups. The floor hockey, the local community volleyball area, the English as a second language course, the automobile licensed training company could rent school space or get a permit to use a school space. And it was the policy of the school boards and of the union that a janitor had to be on site whenever people were in the building. So, they didn't want people to have slips and falls and things like that, and turn the lights on and make sure the heat's working and make sure there's not a fire. So it was a policy that there had to be if they rented the school out or someone got a permit, you had to have a custodian on duty. And I guess they rotated through their custodians from 3 to 11 p.m. Maybe it's a small school and he was the only person there, or maybe every second week it was his responsibility to do Friday nights. Don't know. But it was in the collective agreement that he was required to do it with the school board, and he didn't want to do it. And so they fired him, and they found that it was not a bona fide requirement that a custodian be, no, it was a bona fide requirement for a custodian to be present, but it wasn't a bona fide requirement that it always be the custodian in the manner in which they scheduled them. So it could have been a custodian from another school. It could have been the custodian from another shift. It could have been, they could have rented the school out at a different time. That they found lots of reasons that they could reasonably accommodate the person. So on the face of it, it looked like a bona fide requirement. Custodian must be present, but it wasn't a requirement that every person should be present all the time for it. So that was upheld. So another case of systemic discrimination. Now, boy, Hockey Canada, boy, with they're an organization in trouble. I think they're the organization that's been under a lot of scrutiny because of the London sexual violence case with respect to the Team Canada players. They went to court. They were all acquitted of those charges, and Hockey Canada came under a lot of scrutiny with respect to how they handled it beforehand, and what they did to try to alleviate the possibility and potential for these kind of things to happen, how they handled it afterwards, and how they dealt with the problem. And, unfortunately, Hockey Canada has been under a lot of pressure too, because prior to that, they were under a lot of issues with respect to transgender status in male and female sports. And so we know that it is a controversial topic, and more so in the United States than anywhere else in the world, about allowing transgender people to participate in the sport gender that they identify with. And so I don't think they got into trouble with respect to, say, for example, allowing girls who identified as a male to participate in male hockey, or they didn't get so much even in trouble as men identifying as a woman, a boy identifying as a girl, participating in female girls hockey. What they got in trouble over was change rooms, and whether or not they were going to let the people into the same change rooms, and whether they're going to disclose to people whether or not they were transgender. They got into problems with respect to their training of their referees and their arena and coaching staff. And so the resolution that they came to was that they would provide training to all of its Ontario-based trainers and coaches on gender identity and gender expression, including training on discrimination and harassment, and what it looks like. We're going to talk a little bit about discrimination and harassment in a few minutes. And that they would amend their co-ed dressing room policies, which would those policies would be publicly posted on their websites and in all of their arenas and branches, that a player has a right to use the dressing room, that it corresponds to the player's self-identity, and a player shall be addressed by the player's preferred name and preferred by their pronouns, and a player is entitled to privacy and confidentiality with respect to the player's trans status, and information about the amended policy accessible staff to volunteers. So they would provide all this training and policies to everybody who worked in the organization. Now, so this was the outcome here. This is not the same outcome that has been consistent all around the world with respect to Olympic sports and with respect to university sports. And Donald Trump has entered into the discussion. So it's getting kind of confusing. But this was considered to be whatever was going on prior to this resolution. They considered it to be, for Hockey Canada, systemic discrimination because their policies systematically and regularly discriminate against trans people. Testing. Okay, let's do a real quick test before we take a break. Oh, we're going to do one more topic before we take a break. Policy provides benefits to some married couples, but not to others. This may be a case of discrimination based on family status. A person is denied a job because of a previous conviction of which a pardon has been granted. So we talked about this. So this has to deal with pardons and convictions. And so I'm just moving some things around on my screen here. An employee has a reaction to dust and chemicals at work and needs to take 2 days off. The employee needs the company to address the WSIB forms filled out by her doctor, but her supervisor refuses to give it. Supervisor says, I'm not going to fill out that form that says that we caused you to be sick. And she's told there's no place for her to work in the company because they don't want her filing workers' compensation safety files and forms and costing them all kinds of money and claims every other day. And so first off, allergies, a form of a disability. And so this was systemic discrimination based upon a disability, one of the 11 grounds of discrimination. A female employee was an excellent employee with performance record and announces that she is pregnant. Congratulations, Mom. And immediately her employer begins to identify performance issues that led to her eventual dismissal. And this says it may be a case because maybe her performance did wane, maybe. But it would, if this was only and directly related to her announcement that she's soon to be a mom, then this would be discrimination on a family status. It can get confusing, right? A person's performance could simultaneously decline at the same time as something else happens. You know, a person could say, hey, I'm getting married next month or in a year from now. And then for the next year, they don't spend any time doing any of the work. They spend all their time planning their wedding. And they just fail to meet their performance objectives over and over and over again. And quite frankly, that's got nothing to do with their family status. That's got to do whether or not they remain focused and productive at work. It could have been anything. It could have been their favorite sport. It could have been their participation in a dance competition. It could have been their hope and desire that their children get into university. Who knows what might have been causing this person tremendous amount of stress, but if and affecting their performance. But if their performance actually wasn't bad, and yet the supervisor went, "Oh my geez, I don't want to have somebody around here who's going to have a family," then that, of course, would be discrimination based upon family status. An employer assigns her employee to weekend shifts without recognizing that some employees observe the Sabbath and cannot work on those days. This may be a case of discrimination. Of course, we talked about this already, based upon B, religion. And number 6, an employer's physical fitness requires, an employer's physical fitness requirements are based upon the capacities of an average 25-year-old instead of being based upon the actual requirements of the job. Man, I don't even like the wording of that statement. I don't know what the physical fitness is of an average 25-year-old, but basically it's saying, hey, um, if the requirements for the physical fitness test are not related in any way to the requirements of the job, then it could be age discrimination. In this particular case, they're saying only young people would be able to do that. And so, whatever. Harassment. Is harassment a form of discrimination? Well, yeah. In some provinces, again, we use Ontario as an example because very often things start in Ontario and they spread to other places. The harassment is a form of discrimination. I mean, it's the behavior that arises, it's an unacceptable behavior that arises as a fact of discrimination. And it involves an unwanted physical or verbal behavior that offends or humiliates a person. Generally, harassment is a behavior that persists over time, and it's a series of incidents, not just one event, but it can be one severe event, which has a lasting impact on the individual. So a serious one-time incident can also sometimes be considered harassment. So if a person does something bad, a person one employee asks another employee out on a date and they say, no, thank you. And then they leave it at that. And then 3 weeks later, the employee goes to their boss, says, I think I'm being harassed. I don't know, I feel so uncomfortable at work. My coworker asked me on a date, I said no, and that's harassment. Well, it's not harassment. It would only be harassment if the person said no, and then they asked them again and again and again, or if they started to treat them differently and badly as a result of hearing no, then that would be persistent and consistent overtime behavior. But if a person did something really bad, posted inappropriate photographs of their co-worker on the company website, of which nobody can get that image out of their mind, that would be considered a very severe incident that had a lasting, maybe even a permanent impact. So that one incident would absolutely be considered harassment. But usually for something to rise to the level of considered harassment, it would occur more than once on a persistent basis. So making someone unwelcome remarks or jokes about race, religion, sex, age, disability, or any other grounds of discrimination. So, by the way, I'm going to sneeze. Excuse me. By the way, it would be against a company policy for somebody to be mean to another employee. It's only considered discriminatory harassment if it ventures into one of the 11 prohibited grounds: race, color, place of origin, sex, sexual orientation, family status, religion, age, sex, sexual orientation. I'm repeating myself. The 11 prohibited grounds. So a company can have a policy that says you must treat people with dignity and respect, and you can't be mean to people, and you must be polite at all times. And so somebody who's persistently impolite for another reason would not be considered discriminatory harassment. It's just harassment. And it would still be wrong, but it wouldn't be covered under the Human Rights Act. So if the person threatens or intimidates you because of some of these prohibited grounds, makes unwelcome physical contact with you, such as touching, patting, pinching, punching, that can also be considered not only harassment and a violation of human rights, it can also be considered assault. Does it have to happen at work? Well, it can happen outside of work. If the relationship is primarily from work, but then the person persists to harass you outside of work, the employer's got an obligation to consider that workplace harassment because it's affecting people at their workplace and arose because they met each other at the workplace. Is there a time limit for a complaint? The answer is yeah, 12 months. That in Canada and in most provinces, it's kind of like, hey, listen, if it was serious harassment, you need to speak up about it. Now, We hear stories all the time in um, sexual assault cases, things that make the media, that make the press. They say, well, why did you wait for 12 years to tell people about it? Or why did you wait for 2 years, to tell people about it? Why didn't you deal with it in the time if it was so bad? Were you complicit in it? Were you a participant? Are you a bad person too? Like these things happen all the time. And um, and the the problem is that people's opinions can change and their um, interpretation of past events can change. And so, with respect to it falling under the Human Rights Act, I'm not talking about criminal acts, that's a different story entirely. But with human rights acts with respect to harassment, saying, hey, look, if you're being harassed, you better speak up. You got 12 months. Now, if it's 12 months from the last incident, so if a person harasses somebody for um, a year and they say, stop doing that, stop doing that. And then eventually they stop doing it and they go for 11 months and they harass them again. And then they go for 11 months and they harass them again. Then you can take the last incident date, you now have 12 months from that, and you can include before it, everything before it. So it's 12 months from the date of the last incident in order to make the complaint, but everything that happens, regardless of how long that time period was, can be included. And so, this is designed for two reasons. One is to, if we put a time limit on it, it means, hey, look, if we want this problem to go away, we better speak up now. So it's intended to try to make things better, quicker, faster, to encourage people. If you want to get something done about it, you got to speak up. And it's also designed to allow for credibility in the complaint, because as time goes on, some types of harassment might be more and more difficult to establish. And so let's get it done in a time period when it's more likely to have credible information and witnesses and accuracy. So, multiple choice question. Identify identify and select answers below that, here we go again, another negative, that do not constitute harassment. Discrediting the person by spreading malicious gossip or rumors, ridiculing him or her, humiliating him. Yeah, a single incident or isolated incidents such as an inappropriate remark or having an abrupt manner. So the first one is pretty obvious, is harassment. The single incident of an inappropriate remark or being rude or abrupt is not harassment. It would rise to the level of harassment if it persisted, if you asked the person to stop, if it was based upon prohibited grounds, then it might rise to harassment, but not a single incident. Unwanted sexual advances, which may or may not be accompanied by threats or explicit or implicit promises, well, that's harassment. Making rude or degrading and offensive remarks, well, that's harassment. But a friendly gesture amongst coworkers, such as pat on the back, hey, please don't touch me. I don't appreciate that. If everybody's patting each other on the back and you're at the company softball game and people high five and chest bump and pat each other on the butt as they're going by, then say, hey, no touching. And so this friendly pat once is not considered harassment, but not taking heed to the request for no touching and consistently doing it or repeatedly doing it would be eventually rise to the level. Isolating the person by no longer talking to him or her and denying him or her, ignoring them or their presence, distancing them from others, yeah, that would be harassment. So both B and E are forms, or were not forms of harassment because the single incidences did not rise to the level. So we hear this term all the time, quid pro quo. It means this for that. You give me this, I'll give you that. It's very often used in business and in politics. What did you get in exchange for that voting for that legislation. What's the quid pro quo? Um, but when it's used in the case of um, workplace quid pro quo, it's very often used with respect to the sexual harassment. Um, so a quid pro quo occurs in a workplace when a manager or an other authority figure offers or hints that he or she will give the employee something, give you a raise, give you a job, give you a promotion in return for the employee's sexual satisfaction or satisfying their sexual demands. And so while the term quid pro quo is not exclusive to sexual misconduct in the workplace, very often when it is used in the case of um, um, human rights, it is related to that. Um, Changing work standards after an employee consistently refuses to go to a date. So now you have to sit in the corner. You're not going to get your promotion. You're not allowed to participate in the big deal, the special client. That would all be harassment through quid pro quo, disciplining or firing subordinates after they break up. So it's not against the law for two employees, a senior and a subordinate, to date or marry. My goodness. Um, I don't know what percentage of people have met their spouse at work. And so it's not against the law. It's not a good human resources practice. And most companies have policies around that and about disclosure and about working relationships and personal relationships. Um, but um, when two people have a romance at work and one of them has power or seniority over the other, and then their romance ends and the person uses their power or authority to reprise or penalize the person because of their personal relationship or their failed personal relationship, that would be quid pro quo harassment. A job applicant also may substitute any kind of harassment in a hiring decision was based upon the acceptance or rejection of sexual advances. And so, my goodness, I just hope that that doesn't happen. It's hard to even imagine, but clearly a person saying, hey, yeah, great interview. How'd you like to go with me for coffee or a drink after work? And we'll talk about it more. And that might start to get into the wrong area of and considered quid pro quo. So, Human Rights Act, the act in itself, it's the principle that all individuals in Canada should have an equal opportunity to make for themselves the lives that they're able to and wish to have, and to have their needs accommodated when it's reasonable. And the act is meant to promote this equality by prohibiting discriminatory practices in the 11 areas of prohibited grounds based upon these specific attributes, these 11 specific attributes, such as race, ethnic, sex, or sexual orientation, gender, so on. So um, it is wrong to be rude and mean to a person. It is wrong to treat a person unfairly. It is against the Human Rights Act if the reasoning behind the source of this rudeness or unfair treatment is based upon one of the 11 prohibited grounds. It is now 2:30, time for our 10-minute break. Then we're going to move into DEI and the controversial topic that has been so in the media in the US and found its way into Canada last year. Again, reminder, please, as you go off on your break, don't leave the room and try to get back in again. I'll probably miss you and not be able to let you back in again. Just keep your camera off and your microphone off. When we come back here at 2:40, we'll have an opportunity for people to ask some questions before we jump into the second half of our program for today. So I'm going to turn my camera off, turn off my microphone, and I'll see you back here in 10 minutes. waiting for me. I apologize for being a minute late or so. And welcome back. Any questions from our first half on human rights? Okay, moving right along again. We're going to try to get finished at about 10 minutes to 4 today, or quarter to 4. We'll move really quickly through some of the next few principles. And the next part is going to be on diversity, equity, and employment equity and inclusion. And so, first off, let's talk a little bit about the Employment Equity Act. So most provinces don't have specific employment equity legislation. As employment equity legislation is in Canada is very unique and specific in that it's meant to deal with creating a representation of the workforce that represents the community groups or population. So if, for example, if you had 50% women in your community groups and population, but you only had 10% women in your workforce, you want to ask the question, why is that? Is that because of some form of discrimination? Is it because of some policies that we have? Is it because of the way that we advertise, or is it just the way that it is? So we take a look at these four in the federal legislation. We'll take a look at these four specific designated groups: women, people with disabilities, Aboriginal people, and people with visible of visible minorities. And so visible minorities can be really anything. Very often areas of disability for visible minorities, but not necessarily. It can be people of color, race, religion, place of origin, sex, sexual orientation, so on. So visible minorities is sort of like a general captive for those areas of prohibited grounds in human rights where people might know or see the group that they might belong to, and then make decisions about hiring. And sometimes, by the way, the Employment Equity Act, the federal act, is not designed to force people to hire people out of specific groups. It's to achieve this equality in the workplace so that no person shall be denied employment or opportunities or benefits for reasons that are unrelated to their ability. So we want to remove the barriers that are unrelated to their ability, and this would over time correct the conditions of disadvantage in employment experience by these four groups of women, Aboriginal people, persons with disabilities, and members of visible minorities. By giving effect to the principle that employment equity means more than treating people in the same way, but also requires sometimes some special measures to accommodate those differences. So, for example, say, hey, everybody has the opportunity equally to get into this building. Everybody has to get up the same 7 steps to get here. We're not discriminating against anyone because everybody's treated exactly the same. Well, we're not giving everybody equal opportunity, because people with disabilities can't necessarily get up those 7 steps. And so we're not going to treat people the same. We're going to sometimes treat people, we're going to treat people so that it has the appearance and the effect of treating people the same, which might mean a special measure by putting in an elevator or an escalator or a lift or something to help people to get up those 7 or 2 steps that exist. So we're not treating people the same. We're treating people differently so that they can be ultimately treated the same. So the federal government, now we're not federally regulated, our industry, and so this legislation doesn't directly apply to us. But the federal government's got this thing called the Provincially Regulated supplier to the federal government requirements. So the labor program is responsible for ensuring compliance with the employment equity legislation that exists in the federal government under the federal contractors program, which covers provincially regulated employers, us, if we've got more than 100 or more employees who have been awarded a federal government contract for goods or services of more than $1 million. So what that means is you got to get a temp contract or a recruitment contract for more than 100 people and for more than $1 million. At first, people thought, did they get a contract for $1 million and do they have 100 employees? But over time, it became apparent that if it doesn't affect 100 employees or more going to the work in the federal government, so mostly this affects companies in Ottawa and the National Capital Region and in communities or companies that rely heavily on federal government contracts. So you can go to the Employment Equity Contractors section of Employment and Social Development Canada and find the rules of this. And it says that we need to conduct a workforce analysis. So what's the breakdown of the statistics of the people in our community in those 4 designated groups? And we have to then do the same thing we have to conduct a workforce analysis by taking a look at our workforce and say, how well are those 4 designated groups represented in our workforce? We have to compare that to the statistics of the community that we work in. We have to take a look at our systems and processes, how we collect the data, where we save the data, how we advertise what we do, and is this are there any accommodations that are required? Then we have to take this information and we have to create a plan. We have to document the plan. And then we have to implement the plan, establish and sustain an employment equity program. And then once a year, we have to submit this annual report to the federal government that says, hey, here's our workforce analysis, here's our review, here's our plan, here's the results for our plan. So the employment equity involves all of the following, except for what doesn't it involve? Identification of systemic barriers to employment opportunities that adversely affect designated groups. Yes. Government imposed quotas. No, there are no government imposed quotas. Nothing in employment equity legislation says you need to hire more people of this designated group or that. Does not say that. It does not say that you will be penalized wrong or fail if the results don't turn out to be some set of goal or quota. It does not say that. It says, what's the percentage of Aboriginal people working in your company? 2%. What's the percentage of Aboriginal people in your population around your workplace? 6%. Why would that be? Have we done anything in the way that we advertise, we recruit, we get referrals, we promote our business, that we communicate to the community in a way that would unintentionally, unwittingly have disregarded that particular community? Why are they underrepresented here? And so you take a look at it, you do an evaluation, you make a decision, you create a plan, you implement the plan, you go ahead and do things differently, and you hope that it has results. And no one is ever penalized for not getting the results, unless, of course, they're disingenuous results. If people are doing the things that seem to make reasonable sense in their plan, there might be lots of reasons that have nothing to do with employment equity as to why particular groups don't want to work in your company. So it does not have government imposed quotas. Plans to overcome employment barriers? Yes. Reasonable accommodation? Yes. Be proactive in planning an annual employment equity plan? Yes, it does. So, questions for chat. What are the 2 major demographic pressures affecting the Canadian labor force today? A large number of baby boomers approaching retirement age. Hey, you know what, too? It's not just that there's a large number of baby boomers approaching retirement age and that somehow we need to either make more babies or we have to keep our immigration numbers high so that the number of people working in the workforce are generating enough taxes and revenue to support this large bubble at the top of older people who have got more healthcare needs and other special needs as they get older. If the population declines, and if we have less than 2.1 birth rate per family, because you need 2.1 people to be born in a family just in order with normal death rates and so on, just to say that this generation's got the same number of people as the generation before it. Otherwise, your population declines. So therefore, you have to have immigration. And then there's all kinds of issues around immigration. Do we have housing for people? Because they're not coming in as babies. They're coming in midlife. So now we have to have a job. We have to have a place. We have to accommodate them. We have to have housing. Are we being selective in who we let into? It creates a whole number of issues that affect our workforce. And so we've got this shortage of young people who are going to replace elderly people. But also, what's really messed up demographers is that old people like me aren't retiring. We love to work. And so where maybe 15 or 20 years ago, they were running advertisements on the television for Freedom 55, encouraging people to retire at age 55 instead of age 65. Now 65-year-olds are saying, man, I got lots more to do, and I need to finance that doing. And so and I love my work, and I like making a contribution to the community and to my family. And so we've got this big bubble growing up here. We need to support it down there. We've got older people with baby boomers entering their 65, 70, 75 years old now. Maybe up to 80. I'm not sure exactly where the baby boom begins and ends. But we've got this group of 64, 65-year-olds to up to 80-year-olds. So in that 15-year baby boom category. And we need to support them somehow. And these create lots of issues. So how do we address the issues? I don't know. We got to address the issues through immigration, through work, through workplace policies that allow older people to continue to work, by allowing elderly people to participate in training of younger people and of immigrants who are going to fit into some of the 11 areas of prohibited grounds of discrimination, so that we create equal opportunity for them to fill spots in our workplace. It's a complicated issue. So in Ontario, and for Ontario only, we've got this thing called Accessibility for Ontarians with Disabilities Act. And the Act speaks to developing and implementing and enforcing accessibility standards in order to achieve accessibility for Ontarians with disabilities with respect to goods, services, facilities, accommodations, employment, buildings, structures, and premises. And so this all started 10 years ago, more than 10 years ago, and is supposed to be totally finished by this year in 2025. And so back in, it was more than 10 years ago, I think it was around 2013, 2012, it was introduced. The first stage was a customer service stage. This is where all of our employees were supposed to be trained on how to identify and accommodate people with disabilities. We need to get information and communication for them. So how do we, is it on our website? Do we use Braille, or what about people that are hearing impaired, visually impaired? How do we communicate all this information to our employees and to the community and to our customers with respect to how they're going to be accommodated? We've got to talk with, they want us to make policies in our workplace with respect to employment and accessibility to employment. Big one was transportation. So if you live in a municipal, if you live in Canada, of course you do, you've noticed all of these new buses, and you think it's just technology, but if you're in Ontario, a lot of it was driven by OADA, because the municipalities were required that before 2024 that they had accommodated people with disabilities on public transportation. So Telters, buses, more wheelchair spaces on buses, buses that lower down to allow people with walkers and canes to step up into the buses. Um, Changes in policies with respect to wheel trans and wheel transportation that is offered as to supplement the normal busing and rail that they offered in their communities. And then finally, there were some issues with respect to the built environment, and it really affected, first off, municipalities and government in terms of the buildings. So this is about ramps and about railings and lifts and um, elevators and all parking. So you'll notice now, because of the legislation is supposed to be fully impacted, how much more disability accessibility parking there is. You know, I was at a hospital this morning uh, visiting a client, and every floor on 7 floors of the parking had like 10 spots right beside the elevator that were all designated wheelchair parking. And I noticed these things because I have a daughter who for her entire life has been in a wheelchair. So we notice pretty quickly where wheelchair parking is and how accessible it is. But it's never been like this before. And all of this isn't just because we're nice people, but because of the Ontario Accessibility for Disabilities Act. So, you know, these are a little bit older statistics. I think they should probably be updated, but 1 in 7 Ontarios is known to have a disability. 95% of disabilities are hidden and nobody would ever notice it. It's established that 1 in 5 Ontarians will be 65 or older. So now, this year, 1 in 5, 20% of the population, 65 or older, and half of that group will have some form of a disability. So while 20% of the population has a hidden disability, half of the people 65 and older have got some form of visible and invisible disability. More than 500,000 Canadian adults have some form of vision loss that's not corrected by glasses, and more than 1 million live with some form of hearing loss that's not corrected by hearing aids. So there's all kinds of things. I think technology has come a long way, making a big difference. Can't even touch the topic with any real significance around the issues of mental illness, which affects Canadians. So pervasive. Every family, everyone we knows someone who suffers from anxiety, depression, having people in their families with memory loss, Alzheimer's, and dementia, people who are dealing with stress, and all and then every clinical name that you can think of for people with multiple personalities and schizophrenia and you name it. There's just, you know, a list a mile long of the definitions of different types of mental health issues, and they also come in a spectrum. You know, and I suppose that autism itself would be considered a mental health issue. That they all come with some sort of a spectrum where it's noticeable in some, not noticeable in others. And so the question is, you know, when people aren't behaving the way that we expect them to behave or we want them to behave, to what degree of responsibility, just asking the question, to what degree of responsibility do we have to attempt to accommodate that person? Do we have a right to ask? How can we accommodate a person if we don't know? But then how reasonable would it be for you to assume that maybe they don't want to act like that? Maybe they won't always act like that. And so to what degree do we condone behavior? Do we accept behavior? Do we accommodate behavior, abilities through the person's abilities that are affected through their disabilities? And I don't need to, I'm not going to answer those questions for you because every situation is different and unique and needs to be evaluated on its own merit. But the issue is that the AODA is intended for us to be more consciously aware of the fact that people have disabilities and that they're more pervasive than we often think and believe and know, that they are hidden and invisible, and that we need to create policies and practices and physical space and technology and communication methods and training methods that will help us to deal with things like physical disabilities and infirmity and malformations and disconfigurations and mental impairments and developmental issues and learning disabilities and mental disorders and all of the things that would fall under the category of some form of disability that requires assistance for accessibility. So we're all required now to have an AODA in Ontario policy statement. And by the way, if you're not in Ontario, you should probably have some of these as good business practices anyways. So the organization committed to, so this is an example of one that I wrote many years ago. The organization for a customer, this is an organization that is committed to providing exceptional accessible services for our customers. Our services will be provided in a manner that respects the dignity and independence of all customers. The provision of services to persons with disabilities will be integrated wherever possible. Persons with disabilities will be given an opportunity equal to that of given to others to obtain, use, or benefit from the services provided by and on the behalf of our organization. So first off, before we go ahead and do anything, we need to have our CEO or our executive and our management set out and say, this is what we set out to try to do. So we have to have a training policy. We have to have assistive devices and service animals policy. We have to have a policy around notice of temporary disruptions. What happens when the telephone system's down? What happens when the elevator's broken? How do we communicate to people with disabilities how to get access to our space or not get access to our space or reschedule their appointment? We have to have a feedback process that is built into the system so that when people have a complaint and they experience our business, that they can tell us how they feel about it so that we can make changes to our policies and Kaizen, continually improve them so that we continue to meet our stated goals and objectives. And we have to have a notice and format of availability of documents. In other words, we have to be able to have things that are audible or large font or braille or something, that we have to have them in a format and available to people. So DEI, diversity, equity, and inclusion. So, what an honorable and decent principle. Except for in the US recently, funding has been removed from universities that had a DEI policy because now they're being accused of over-representation of visible minorities. That their DEI policies, instead of creating opportunity and fairness, that somehow resulted in quotas, and that those quotas tipped the scale, and that people weren't given an equal opportunity, they were given an unfairly advantaged opportunity. Whether that's true or not, I don't really know. I suppose it could be true somewhere, but certainly not true everywhere. But DEI in the US under the current administration has become a dirty word. As a matter of fact, when there was a airplane accident, the president there said, well, the air traffic controller was a DEI hire. He just made that up and tried to imply that the accident occurred because the air traffic controller was unqualified for their job, but hired because they were a visible minority. So this is ridiculous. It's finding its way into the US and American zeitgeist. And it's important to know that when we talk about DEI in the Canadian context, in the way that our human rights policies and our federal employment equity policies and our employment standards, pay equity policies, and our OADA policies, that none of these involve quotas. They all deal with the issues of not unfairly discriminating and disadvantaging people, but providing an environment where everyone has the opportunity to participate and contribute. And it is nothing like what the dirty word has been created in the United States, where it's meant to say there has been some inappropriate, unfair selection process to allow unqualified people to meet quotas in their selection for jobs. This is probably not even true in the United States. I'm certain in my heart that in the vast majority of cases, that is not true. But it's turned into that belief system in the United States. And it's important to understand that when you hear the expressions DEI or anything using the words diversity, equity, and inclusion in Canada, that we have never had any laws, policies, or incentives to organizations to meet quotas. We've had penalties for companies that were obviously found to be discriminatory, but we've never had bonuses, opportunities, and funding for people that, for lack of a better expression, it's a terrible expression, participated in reverse discrimination, because that is not what DEI in Canada is. So we think about it as gender diversity. What makes up the composition of men and women and non-binary people in a given population? And is that population of our community reasonably reflected inside our organization? We think about age diversity, and I talked about, the baby boomer bubble and, the aging population. So do we have only young people in our organization? Do we have only older people in our organization? Are we covering all the gens, in a proportion that reflects the proportion of the qualified people in our community? So do we have age diversity? Do we have ethnic diversity? Do people in a group share common national or cultural traditions? Or do they represent different backgrounds? So is everybody in the organization from the same religion or from the same country or from the same culture? Or are we representative of the communities that we work in? And listen, and physical abilities and neurodiversity. So, are we accommodating people and finding ways that they can make a contribution in our organization, or are we discriminating and say, hey, it's not worth the hassle, and it's not worth the effort? And here's the thing. It is worth the effort to look at gender diversity and age diversity and ethnic diversity and physical ability, neurodiversity. Having people who work in your company that represent different cultures and different ages and different genders and different ethnic diversity allows you to create policies and practices and to develop customer service methods and to understand and better communicate with and better serve the customers that keep you in business and make you money. And so it doesn't make any sense that if we've got a culturally diverse group of customers, that the people who serve them wouldn't be as equally culturally diverse. As a matter of fact, it's a great business opportunity. For example, if you operate a service business that people who speak a particular language represent 20% of your population, then maybe 1 in 5 of your employees should be able to speak that language. So that when they come into the store and they phone your phone number, somebody can communicate with them and understand what they want and what they need and can satisfy their needs. That it doesn't have to be a burden on your company. It shouldn't be a burden on your company. It should be an opportunity for your organization to figure out how to expand and positively exploit the entirety of the marketplace, which is equally diverse in gender, age, ethnicity, and physical and neurodiversity. So equity refers to this fair treatment for all people so that the norms and practices and policies in place ensure identity is not predictive of opportunity. So that your identity doesn't say that you will or you won't be successful. That your identity doesn't suggest that you are qualified or not qualified for a job. Equity differs from equality in a subtle but important way. Equality assumes that all people should be treated the same. So the example of, yeah, all people are treated the same. They all only have to make good up those two steps. But equity takes into consideration the person's unique circumstances, adjusting their treatment accordingly so we get an end result that is equal. So if we want all the people to have the opportunity to buy our stuff, and we've got two steps, then we need to get into the store, we need to provide a lift or a ramp or something so that people in a wheelchair or walker or with a physical disability can also get into the store, so everyone has the equal opportunity to buy. So treating people sometimes equally and just equally sometimes means treating some people unfairly. So if we gave a test, if we needed to test a person on their knowledge of math before they could work in the math job, but the questions were all written out in English, and we didn't give the opportunity for people to, and yet the job has nothing to do with people talking or nothing to do with writing communication, and it has to do with dealing with the public, then maybe the people who understand the question written in English might understand the question better and do better at the results. So we give people the opportunity, at least in French and English, let alone other languages, to have equal opportunity to prove how darn math smart they are. Inclusion refers to how a workforce experiences the workplace and the degree in which organizations embrace all of their employees to participate in meaningful contributions. So sometimes we have diversity in our workforce, but we don't have inclusion in our workforce. So once we've diversified the workforce, but we don't include everybody in the decision-making process or the feedback process or the satisfaction process, we don't include everybody fairly, the same way in similar fashion so that they can make a contribution, a meaningful contribution. Companies that are intent on recruiting diverse workforce must also strive to develop a sufficiently inclusive culture, such that all employees feel their voices are heard, which is critical if organizations want to retain their talent and unlock the power of their diverse workforce. I try to write these things in a way to say, man, this is good for business. Listen to your employees and don't assume that everybody thinks the same. Assume that everybody thinks differently. And as much as we've learned from recent CNN and Fox having totally different viewpoints, that they see the exact same circumstances in the world in entirely different ways. And it's kind of frustrating. But it's also a learning experience for us to understand that people of different ages see the same things differently. People of different cultures see the same things differently. People of different marital statuses and family statuses see the same things differently. Some people say, oh, that's awesome and so fair. And some people say that's so not awesome and so unfair. My mother doesn't get an opportunity to do that because of her hearing. And so how do we get my mom to be able to participate equally in this? So we need to listen to our workforce and engage them so that we're inclusive, not just diverse. So we talked about DEI today and equity. We talked about human rights. We talked about employment standards yesterday. We talked about employment equity, federal employment equity, about AODA in Ontario. And finally, our last topic is about privacy. And the PIPEDA legislation, how it's pronounced, stands for Personal Information Protection and Electronics Documents Act. Now, PIPEDA legislation is one of these interesting and unique legislations where the federal government, through a charter, comes along and says, people have a right to access to information and people have a right to the privacy of their information. And we need to find a balance so that they can get access to information about their governments and their government's policies and practices and spending and things like that. And yet a person's personal private information doesn't serve in the public good whatsoever to have it available to everyone. So when companies and organizations and governments are collecting this information in order to provide the services, that they have an obligation to protect that information, whether it be physical in the form of documents and documentation or electronically in electronic documentation. So it protects personal information in the hands of private sector organizations and companies with guidelines for how you collect the information, how you use the information, whether you're allowed to disclose that information through the course of this commercial activity. Now, the federal government introduced legislation and said, but this kind of falls under the preview of the provincial governments. And so we're going to allow each provincial government to kind of accept it and modify it as they go. And different provinces accepted it in different ways. Some of them took the federal government legislation and almost entirely exactly, I think maybe the territories, a couple of the territories, entirely and exactly just used it as the federal government wrote it for federally regulated companies and for the federal government. And yet other provinces came along and decided to do it a little bit differently. And we'll talk about some of those differences. But it applies to private sector organizations across Canada that collect, use, or disclose personal information in the course of their commercial activity. And the law defines a commercial activity as any particular transaction or act or conduct or any regular course of conduct that is of a commercial character, including the selling, bartering, leasing of donor memberships or fundraising lists. So we don't want this personal private information to be used in a manner for donations and fundraising and financial institutions to be used in a manner for which it was never intended. So Alberta, British Columbia, and Quebec have their own private sector privacy laws that have been deemed substantially similar to the federal government. So in other words, they just said, hey, we like the federal government's, we're going to kind of keep it just the way it is. We'll just change a few words around, put our government's name in there, and we'll fix up a couple titles and things, but it's pretty much the same. Organizations subject to a substantially similar privacy law are generally exempt from the federal law. So if there's a provincial law in place, then you don't have to worry about the privacy laws of the federal government for that to apply to them, because the information is relevant to how it applies in the province. Other provinces like Ontario, New Brunswick, Nova Scotia, Newfoundland, and Labrador have adopted substantially similar legislation, but they limited it to the use and disclosure of personal health information. It wasn't. Now, by the way, the bank collects your information. They're federally regulated, so they fall under the federal legislation. Provincially regulated organizations come along, and the Ontario government has said, and New Brunswick and Nova Scotia and Newfoundland have said, we like this, but it's not that relevant for, say, for example, employment agencies. Unless the information got something to do with personal health information. So in Ontario, we've come up with the Information and Privacy Commissioner of Ontario. So that's the commissioner who enforces the act. And then we've come along with FIPA, the Freedom of Information and Protection of Privacy Act, the Municipal Freedom of Information and Protection. So now they said, hey, cities and governments, you've got a responsibility, much the same as the federal government does, excuse me, the FIPA has more to do with, hey, I want to see my information. I want to see government information. So you guys have heard of the Sunshine List. I think it's only in Ontario. So the Sunshine List is part of FIPA, Freedom of Information. Where, no, sorry guys. Freedom of Information, where people went to court and said, well, we've got a right to know how much our government employees make. And so if it was a government agency or a government employee, then if you're a police officer or a teacher and you made more than $100,000 a year, then they created this list called the Sunshine List, and it's updated every year. It's usually about a year and a half or 2 years late, but it's created every year saying how much all people who made over $100,000 a year, what job they had, who they worked for. And this is all about the freedom of information, that we all have the right to access certain information, and we all have the right to protect some of our information. And then we've got the Personal Health Information Protection Act, which has to do with things like when you're, this is a big deal again, I mentioned my home care company. So in our home care company, when we're collecting information about a person's health, what medications they take, about who their doctors are, about how old they are, about what their health number is, about whether or not they've got a non-resuscitation, do not resuscitate order. I mean, these are all things that as a health provider, we need to know. We need to know these things. And, we're required by law to keep that information personal and private and protected, so that nobody could accidentally get it. So that, we've got policies in place that talk about what happens if somebody loses their laptop and how is it protected and what are the servers like that the information is saved on, and are those servers located in Ontario and are they in Canada, and what, you name it. So but the bottom line is that in Ontario, it basically says we've got the right, one of the pieces of the legislation says we've got a right to find out about stuff. We can do an access to information and ask how much the government spent on things. That's freedom of information. We've got the right to our privacy of our medical and personal information around health issues. And municipalities and governments who collect information from people because they pay them welfare and they subsidize their housing and they collect taxes on their homes, and all of that, so that governments have got a super responsibility to protect that information so that it doesn't get hacked and found and used by credit card companies and bad people and so on. Not to put credit card companies and bad people in the same category, but so that it's not used for a purpose of which it was not intended. So there's 10 principles that exist in these privacy laws. First is that the organization collecting the information is accountable for every aspect of the rules about how it's kept, how it's protected, how it's given, how it's used. And so there has to be a commitment from the organization and their policies and their CEOs and their owners and their senior management that they're accountable for all of this stuff. They can't just say, stuff happens. It's important that when we collect information under PIPEDA laws, that we identify what the purpose is for collecting the information. And if it doesn't fit the purpose, we're not allowed to collect it. So we have to say to people, we're collecting this information so that in the event if you go to the hospital or there's a medical emergency, that we can do this stuff and that this information will be used by us and only for that purpose and for no other purpose. And we promise that we will not sell this information or use this information or disclose this information to anyone for any other purpose. So we have to identify what the reason is that we're collecting the information, and that there is a connection between the information we're collecting and the purpose. We have to ask for consent. Now, consent, you give us the right to use and keep this information. So you see all the time, you're ticking a box, you're answering a question. Sometimes you're doing something over the phone and they say, you're going to be sent off to a third-party consent thing. It's going to measure your voice and it's going to record the fact that you heard this and you consented to doing it. I've had that happen when I'm using a credit card or when I'm getting things charged to people or whatever. There's no one particular way about consent except for so you can ask for it verbally and document it. You can ask for it by email, document. You can ask for it for a signature on a form and document it. And of course, um, the most legally protected method is to have a physical form with a physical signature and a physical signature of a witness. But that's not practical all the time. So municipalities and governments and doctors' offices, they tend to do that. Come here and sign the form. And you think, what is going? Like today, I had to do something for a customer, and the only way you could do it is you could physically go there, you could mail it, or you could fax it. You could not email a request for an appointment for a medical appointment in our home care business. They wouldn't allow you to do it because they didn't believe in number 7, that getting an email request for information and providing information over an email provided enough safeguards. So, and accuracy. So they asked for consent. In that particular case, they asked for consent and it had to be done by fax. Who's got a fax machine anymore? We have to limit our collection only to the information that is related to the purposes that we identified in number 2. And then we have to limit the use and disclosure and retention of the information so that only the people that need to know the information when they need to know the information for the purposes that were identified in number 2 get access. So in other words, we ask people medical or personal or private information about their credit cards or their date of birth or their family status for their benefits or something. And we put it in the file. And we have to make sure that that file is locked and protected and non-accessible so that everybody in the company can't see it, and that it's only accessed when there is a reason that was identified as the purpose in number 2 that it needs to be seen and used. Otherwise, it needs to be protected and limited. We gotta make sure that it's accurate. So this is why very often they ask for a witness and for signatures and for things. And they ask for people to update it. It's been 3 years since you've done this thing, and now you have to come here and update it again. So this is why banks ask companies to come in and sign documents like every 5 years. It's the same document you signed 5 years ago, just to make sure that it's still absolutely accurate. You have to provide safeguards. So this is the protection, the locked box, the security, the locked filing cabinets, the locked doors on the buildings, the virus protection and hack-proof protection of the servers, all that kind of stuff. There needs to be openness and transparency so that the people who are providing the information, the people using the information all know the policies, practices, and procedures. We have to allow individuals to see what information and access the information we have on file about them. That's interesting. And then we have to have a process for challenging whether or not we are in compliance with laws. So what's personal information? In the federal context, it's all of these things. In the Ontario context, it's all of these things if it's the government or a municipality. And it's only and in the context of private practices, it's only the medical information. So you and I in our staffing services businesses don't have to comply with all of this privacy information unless it's medical, personal. And I would say that from financial record standpoint, if you're collecting credit cards and banking information, just because banks are federally regulated, you're not federally regulated, but man, you really want to protect that information because it's going to find that the bank is going to expect that if they're going to provide a service to you, that you've signed off, just like the federal government has got their contractors employment equity program. The bank has got an obligation to ensure that their customers, when they are dealing with financial information that goes from and to the bank, that they're upholding the same standards with respect to that information that the bank does. So age, name, identity numbers like SIN or driver's license number, a person's income, their ethnic origin, their blood type, their religion, opinions, credit records, loan records, medical records. These are all considered personal information that is protected under privacy laws. Again, federal government, full on. Federal government, federally regulated industries, banks, airlines, transportation, interprovincial transportation companies, telephone companies, all federally regulated industries fall under the federal legislation, PIPEDA. Some of the provinces, British Columbia, so on, PIPEDA, substantially similar legislation. Ontario, New Brunswick, Nova Scotia, written their own legislation that is just the same as PIPEDA for municipalities, but not private sector companies. They've written another piece that has to do with medical legislation, medical services companies dealing with personal medical records. So the same as PIPEDA, but only companies that are involved in collecting and using medical records. So one of these things doesn't belong. Here's another one of the negative questions. Which of these following statements about consent is false? Organizations can generally rely on implied consent. Oh, I started to go down this and tell you about it. There's all different ways you can get consent, but you can't get implied consent. You can't say, we're asking you for this information, and unless you complain about it, we're going to assume that you're okay with it. Can't do that. You have to say, you must give us consent. There's lots of ways to get consent. You can get it verbally, you can get it electronically, you can get it personally, but you can't use implied consent, which means the negative. In the absence of you complaining about this, we'll assume that you're okay with it. Can't do that. So organization can generally apply implied consent? No. The consent mechanism chosen should be clear and unambiguous. Yes. Consent can be obtained in a number of different ways. Yes. So also in every legislation, there's, including employment standards, federal employment equity, AODA, here, human rights, here, in privacy, there's always a section near the end of the legislation that deals with how do you make a complaint and who do you complain to? And this is pretty normal in modern legislation. They say, look, the organization creates its own policies, practices, and procedures. They document it and they make everybody aware of it. And it doesn't have to be exactly the same from company to company, unlike some legislation where they might say, here's exactly, for example, Canada pension legislation. The Canada pension plan says to every company, for every employee, this is the way you have to handle this is the way you calculate it, this is the way you pay it, you have no choices. But in this case, they say, here's the principles that we need to achieve. Go ahead and write a bunch of policies that make the principles. And then publish those policies and practices and give people the opportunity to, over here on the right-hand side, organization of complaint that give them the opportunity, your employees or your customers or the people whose information you've collected, to come to your organization and go to your privacy officer and ask a question or make a complaint. And then you have the policies and practices and procedures in place that are intended to say how you deal with that complaint. And if the person then, people, organization, or person, then feels like, nah, that's a bad policy, it's not consistent with the objectives of the law, then you can go over their head. Or you say, you had a policy, you didn't abide by it, I still didn't get what I want because you didn't even follow your own policy, then you can go over their head. But it's generally designed to say, hey guys, we set out what you got to try to achieve, go ahead and try to achieve it. Only come to us when it doesn't work. And so then the complainant can go to the Office of Privacy Commissioner of Canada, if it's federal, or to the privacy commissioner in Ontario or British Columbia or Alberta, and they can make a complaint to the commission saying, here's my complaint about this organization, their policies and practices and procedures and their employment, their PIPEDA policies are not compliant with the law, or here's their policy, it is compliant with the law, but they didn't adhere to their own policy. And then the privacy officer will then try to seek out early resolution by contacting the company and say, hey, is this really what's going on? Maybe you should do it differently. Here's the way the law really should be interpreted. And the objective is to not penalize people for failing to comply if they just didn't do it right. It's intended to help people to comply. But of course, if people are stealing information and selling information, they're going to get fined, and there's parts of the process for fines and jail and so on. So PIPEDA, it gets confusing it got really confusing during COVID. Did you have to disclose that you were sick? Did you have to disclose that you were living with somebody who was infected? Did you have children and other vulnerable people in your household that you needed special consideration for? That if you came to work and then you came home at night, you would make your mom sick or could infect? There was all kinds of issues around that. So that became just a nightmare of unlimited number of topics that some resolved, many unresolved. And then we've got this forever ongoing issue of the pervasive social media dilemma. People posting things online about their lives, and then companies and employers and coworkers having access to public information about what's going on in their lives and what their relationships are like and who they love and whether they're married and how old they are and whether they're sick. And, there's people posting things about their medical treatments and about their experiences with their children and their relationships and their politics. And you name it, it's all out there in social media. And then, of course, the social media companies and social media platforms, very complicated. I'm absolutely certain that my parents wouldn't have a clue on how to set up their privacy settings on Facebook or Instagram to ensure that only the people that they wanted to see their information or nobody could see their information. They just go with the defaults. They don't know. They don't even know half time what social media platform they're on. They just go, oh, I got a message. And so, and it's surprising that they've taken the time to even use it and participate as much as they do, but complicated. And so very complicated are the things you're posting about your work, or the things that are people at your work finding out information about your personal private life and then making decisions about you at work. Is that discriminatory? Is that an unauthorized access to private information? Or is it, I was authorized to access the information, but now that I have it and I know what your marital status is, am I allowed to, what if I treat you differently? Because I know something about you that I wouldn't have otherwise known. And then can the person complain that you looked? Or can the person complain that you used it? And do they know that that's why they're being treated differently? Oh my goodness. It goes on and on and on. And so the only answer I have with respect to social media is have a policy, write it down, be inclusive, get people in the room, all your employees, lots of employees, all different groups, ages, in the room. Find out, what do they think? How do they want it to apply to them? What should we be allowed to see or not see? How can we be allowed to, if they're on a company provided telephone, are they allowed to use it for Facebook or for Twitter? If they have a LinkedIn account and they say what company they work for, do you want to restrict the comments that they can make on different topics on LinkedIn or Twitter? Because it could come back, they're using a company provided device in order to do things that are not authorized to be done on behalf of, to reflect the opinions of the company. Have a policy. I can't tell you what the best policy is. I can tell you that there's good policies and bad policies. But at the beginning, have a darn policy. Have one. Have a conversation with your employees. Change it, fix it, make it better. But don't go about saying, oh, we'll deal with that problem when it arises, because the problem might be so huge by the time you have to deal with it that it's just undoable. So, do you pay for their data on their phone, but they own their phone? But do you subsidize? Do they use it at work? I mean, my goodness, in one of my companies, where I had like 400 recruiters, we absolutely encouraged everyone to, every day there were job postings, and they would get a feed into their Facebook account or their Twitter account or their LinkedIn account that said, here's all the jobs that we've posted that are on this platform, so that they could repost it. Because we wanted 400 people to repost the things that were posted on our website or on Indeed, or back in the day, Workopolis, and the various other sites are available. So we wanted to, if it was, we wanted 1,000 pathways. We wanted everything that we did in our company with respect to recruitment to be propagated 1,000 times over by our employees, by them putting it on their Facebook account, on their social media account, in their LinkedIn groups, on their LinkedIn profile, so that every day, if we posted one job, it got posted 500 times in 500 different places or more. And what a fantastic contribution it made to our recruitment effort. Boy, we're super amazingly successful. But now we've got all these people with personal LinkedIn accounts and Facebook accounts and Instagram accounts and, Twitter accounts, that X accounts, and now new threads and all these other new sites that now, if you're saying we're encouraging you to integrate your personal profiles on social media with the work stuff, to what degree do you have to control what they do in the non-work stuff? Have a policy. Because sooner or later, it's going to deal with privacy, and it's going to deal with decisions that you're making that are going to feel like you're infringing upon their life, and maybe using criteria that they found out about that had to do with a prohibited ground of discrimination. So there's good policy, there's bad policy, there's different policy. Start with a policy and have different people participate in it. So we've got lots of different resources available. I think on the printouts that you guys got, there's a couple clicks and links on the back. There's just an unbelievable number of resources available. But we finished 15 minutes early today as planned, and I wanted to open up the floor and ask people if they would turn off their mutes and come on board and have a quick conversation about any of the topics that you saw or heard about today. Silence again. Okay, I'm going to assume that silence is good, that you are silent because, boy, it was just so informative.